Well, welcome back, everyone. And Alta Richards is going to be our final speaker for today. Alta will be speaking to us about the Liquor Amendment Bill and the front pack labeling. Alta is the executive in the ENS's Corporate Commercial Department. She specializes in healthcare and pharmaceutical law, the food and pet food industries, as well as food and advertising law. She also has experience in the transportation and rail engineering sectors. Alta, without further ado, we'll hand over to you to take us through the final stretch of our day.
Thanks, Neo, and thank you to everyone. I'm sure it's been a bit of a long day for some of you who have managed to sit through all of the presentations. So I'm hoping I won't take the full 45 minutes, but let's see where we get to. And I'm just going to flip the order around and deal with the front of pack labeling first. And so I think no discussion or no meaningful discussion in relation to front of pack labeling or nutrient profiling model can really start without looking at the background of South Africans' health needs currently. And just to give a few facts and figures, in 2016, SA Demographic and Health Survey reported that overweight, obesity, and hypertension prevalence have been steadily on the increase since 1998. So in 2016, the figures in South Africa were 31% of men and 68% of women were overweight or obese. In 2018, a study was conducted in terms of which 83% of packaged products that were evaluated in SA supermarkets were either processed or ultra-processed in terms of the NOVA classification system. And as you're aware, consumption of processed food, ultra-processed foods in particular, is linked to non-communicable diseases. And over time, South Africa has moved from an infectious disease jurisdiction to an NCD jurisdiction. There's a recent report by the World Obesity Federation that anticipates that SA is likely to have the 10th highest level of childhood obesity by 2030, and that's in the world. And with approximately 28% of children between the age of 5 and 19 being obese by 2030. A recent review of all adult dietary studies done in SA between the years 2000 and 2015 found that there is still a high level of micronutrient deficiencies. In this regard, a predominantly carbohydrate-based diet with low nutrient density is still common in South Africa. So against that backdrop, what has been the legislative journey towards front of pack labeling in South Africa? Anyone who's on the call that's in the food industry will recall in 2010, there was the introduction of R146, which amongst many other requirements, brought in requirements for nutrition claims and nutrient content claims, but it was still silent on front of pack labeling. In 2011, the trans fat regulations were introduced. And then in 2014, R429 was published for comment. And these were amendments or supplements to R146. That contained a nutrient profiling model. It was intended that there would be sort of an NPM calculator on the DOH website, and you would be able to sort of put your product through that and see if it sort of passed the requirements or didn't meet the requirements. And it also introduced voluntary front of pack labeling, but if you were going to do front of pack labeling, then there were certain requirements. It's provided for a traffic light system that some other countries in the world have. And the nutrients that were selected for use for this traffic light system were energy, total sugar, fat, saturated fat, and total sodium. So in terms of a traffic light system, as you'll be aware, you can conceivably have a product that is green in terms of some nutrients and red in terms of others. So it allows a manufacturer to highlight certain positive attributes of the product, even if there are some negative attributes in terms of excess sugar or fat or the like. So as you'll also be aware, R429 was never published in final form. Then in 2016, the sodium regulations were introduced, which brought in a progressive reduction of sodium in certain foods like bread and crisps. Then at some stage, the Directorate of Food Control gave way to the Directorate of Nutrition in terms of dealing with these labeling issues. And in September 2019, the Chief Director of Nutrition at the Department of Health stated that mandatory front of pack labeling may be introduced by the end of 2019 or early 2020. And that it was indicated that there would be a warning sign on front of pack for products that were high in fat, salt, and sugar. So it was indicating that the department was moving away from a traffic light system and looking at more of a warning sign system. So obviously then COVID happened, and Department of Health has had a myriad of other things to concern itself with in 2020 and now in 2021. But if there's one thing also that COVID has taught us, is that obesity also, even in the context of COVID, leads to poor clinical outcomes and a higher mortality rate as well. So it's unclear, at least in terms of the information that I'm aware of, where Department of Health is now and what they want to do. But certainly what's been happening in that gap between 2019 and the present is there has been quite a great deal of academic work that's been done relating to an appropriate nutrient profiling model for South Africa, including front of pack labeling. So to just give you now some highlights or possibly lowlights from an industry perspective from this research that's been published during the course of 2021 by different authors. And the global consensus is that better policies are needed to address the obesity pandemic, internationally and in South Africa. An appropriate nutrient profiling model can underpin policies, including front of pack labeling, restrictions on child-directed marketing. It could ultimately lead to certain types of foods not being permitted for sale in schools, in hospitals, and that type of thing as well. A nutrient profiling model should be developed independent of industry, because in terms of international experience, NPMs that are developed with industry tend to be more lenient. So this is obviously just the views of various authors. And front of pack labeling that includes nutrients to encourage consumption, such as fiber or fruits and vegetables, in addition to nutrients to limit or the warning sign system, can confuse consumers when trying to identify unhealthy foods. So one group of authors has suggested that Chile's 2019 nutrient profiling model should be adapted for South Africa. As you may or may not be aware, Chile's 2019 NPM is very restrictive. Front of pack warnings, rather than a traffic light system, front of pack warnings are mandatory. Products with front of pack warning labels in Chile may not be sold or eaten on or near school grounds. And there's prohibitions on marketing of foods with front of pack warning labels. So that's obviously quite an extreme example that's been implemented elsewhere, but there are authors that support that model for South Africa. And these authors also highlight that I've already mentioned the COVID-19 pandemic link between obesity and morbidity. In another 2021 article dealing with consumer perceptions of front of pack warnings, on unhealthy foods and drinks, the conclusion was that results from the focus groups in South Africa suggest a policy mandating nutrition warning labels could improve consumers' understanding of health risks and help them identify unhealthy food and drinks. And certain design elements, like a black color in a triangle shape with the wording high in and warning language and the use of exclamation marks, could enhance the label's ability to increase perception of the risks of consumption of unhealthy products. Now, obviously, this is like a marketer's nightmare, but that is what is being suggested. So where does this leave the industry? I think every effort should be made by industry to engage the DOH and to try to be part of the conversation around the appropriate and workable nutrient profiling model and FOP labeling regime. There's a risk of a very restrictive regime ultimately being introduced. And if you wait until after regulations are published, that can actually put stakeholders on the back foot. I mean, yes, you always, from a legal perspective, have the ability to submit comments when regulations are published. But as we've seen in practice, these are often not taken into account. Just to use one example from my practice, I remember when the draft regulations for foods for infants and young children were published, and there were extensive industry submissions, including provisions that were, in our view, ultra vires or unconstitutional. And literally, if you work in this area, you'll know that those regulations were published in final form, almost exactly to the word, the same as the draft regulations. I mean, I was thinking back today, they didn't even take into account like where we corrected typos in our submissions. Like it was like literally, it didn't appear to be taken into consideration at all, because there was the whole focus on breast is best. And everything that goes along with that, even impacting on bottles and teats and the like. So, and the issue there is that, from a legal perspective, you can say, well, this regulation is ultra vires or that regulation is unconstitutional. But the issue is that if you operate in the industry, many players in the industry do have a limited appetite to take regulations on review, because you're dealing with a department, or in other instances, a regulator that you have to deal with on a daily basis in your business. So it does lead to quite a conservative approach by industry stakeholders in many instances. And I think where there's other examples of this also from practice is, in terms of dealings with the likes of SAPRA and the Council for Medical Schemes and the National Regulator for Compulsory Specifications. A lot of these regulators also appear to have been quite emboldened by the COVID period. And initially that's because, a lot of things had to be done on an urgent or an expedited basis, or in terms of the disaster management regulations. But I think a lot of the regulators and departments are quite emboldened to potentially overstep the mark legally. And again, we sit with that scenario where if you have to interact with those regulators or departments on a regular basis, industry stakeholders may be loath to go the litigation route. So that's the first part of my presentation. So I don't know if there's any questions.
Thank you. I don't see questions at this stage. I'm gonna double check, but I don't see. Maybe you should go to the next one, set of your presentation, and then we can tackle both of them.
Okay, sure.
Yeah, thanks.
Okay, so when we engaged with the CGCSA to see what it was about the Liquor Products Amendment bill that was of interest, it seemed to be a little bit less about what the content of that amendment bill is, because that amendment bill did come out in 2016, so it's been some time since that was published for comment. And perhaps the area that was a bit more of interest was in relation to, in the context of the lockdown regulations, in terms of the partial and then total bans on alcohol sales, what the rights are of relevant role players in the industry. But in any event, I'll just quickly recap what the sort of the headline changes were in that amendment bill. First of all, there's the creation of a national liquor regulator, which would then take on a lot of the powers that were previously carried out by the minister. It raises the drinking age from 18 to 21. And then there's a number of further restrictions on advertising, some of which are quite clear and easy to understand, and others that I think would be potentially void for vagueness or very hard to interpret. And just to give a couple examples of those, advertisements must, quote unquote, reflect the harmful effects of liquor abuse. So up to now, obviously, there's needed to be warnings that are prescribed by law, but it does seem that that's very much open to interpretation, or to what extent do you have to reflect the harmful effects of liquor abuse in a particular advert, and how does that work with the context of what you've sort of storyboarded, for your product. Also, the contents of an advertisement must not appeal to persons under 21. So that's also, it's slightly different than be targeted at, which I think is a bit easier to interpret. But how do you know what will appeal to people that are under 21 versus someone who's 22 or 24 or 30? I think that's quite a difficult one to interpret. Another restriction is that, advertising, in this case, it would be billboards, have to be at least 100 meters from junctions, street corners, or traffic circles. That seems a little bit arbitrary, but I guess they're just trying to get less eyes on the advertisements. And then you can't have advertising on premises attached to petrol service stations. You can't have advertising near transport facilities. And then they bring in a 500 meter minimum for advertising in relation to schools, places of worship, recreational facilities, rehab facilities, residential areas, public institutions, and other like amenities. So that again is quite open-ended. There is a carve-out for licenses that are already granted. So otherwise, I mean, it's not intended that you would have to move your, bottle store if it's been situated in a particular place near to a residential facility for 10 years. But that does seem, I mean, 500 meters is actually quite a long distance. And the other interesting thing is that Section 34A of the bill creates joint and several liability of the manufacturer and distributor if they supply to an unlicensed person, and then there is some harm or loss that is suffered. And then there is, for contravention of that provision, there's actually a 1 million Rand fine or imprisonment for supervisors and managers, not exceeding 5 years. So, I mean, again, I think just it's clear what this is intended to deal with, and it's intended to deal with a problem that I think everyone that works in the industry knows exists. And that is, it's very difficult, particularly if if a manufacturer or a distributor is also supplying the sort of more informal market, or shebeens, etc. There is a tendency to find it very difficult, particularly when license renewals are every 12 months. It's quite difficult to ensure that your due diligence is in place to be able to not only ensure that your distributors are licensed, and that's quite, relatively easy, but then if you talk about then, every single retail outlet, restaurant, or bar or shebeen, it becomes that this 34A would create quite a big, quite an onerous burden on the manufacturers and distributors, and then it is a criminal offense. So those are sort of the big ticket items, I guess, from the 2016 bill. So then, sort of moving on to sort of the liquor environment during the lockdown regulations. I mean, everyone will be aware from just articles and other publicly available sources, what some of the arguments have been raised against these liquor bans, at least the outright ban. And the rights that have sort of been bandied about are like the right of freedom to trade, right to human dignity, right to privacy, right to bodily and psychological integrity. But I think fundamentally, I think the one thing we all have to keep in mind is that in terms of the promulgation of regulations, it's quite a low bar that government has to get over, or quite a relatively low hurdle. It's not, could there be something else that government could have done to deal with, the short supply of beds in hospitals and that type of thing. It's basically, are those regulations rationally related to the purpose of the declaration of, of the disaster, and then they would likely be found valid. So is there a rational connection between the ban and the aim of freeing up hospital beds to better deal with medical consequences of COVID-19, to reduce the number of alcohol-related trauma and emergency cases? And so it's always going to be that weighing up in terms of all of the rights. So a lot of it will depend on what is the situation. So if we got to level 1, it's quite in level 1 lockdown, and government was still imposing a ban, well, that may no longer be rationally related. But as you'll probably recall, the series over time of 4 total bans, at least 3 of them were linked to particular surges, or 2 of them were linked to particular surges in not only infection rates, but also hospitalization. So just to give you a little bit of history, and this is now just having a look at the SAB matter when they went for urgent relief in the Western Cape High Court in relation to the liquor ban that was in place during the third wave. As you might recall, on 27 June 2021, there was a total ban on alcohol sales. I'm sorry, and that was the SAB case was in relation to that June 2021 ban. But taking a step back, 15 March 2020 was the declaration of the national disaster. 26 March 2020 was the first hard lockdown, which included a total liquor ban. And the minister at the time had said that March 2020 ban was based on rate of new infections, rate of hospitalization, and capacity of the healthcare system and its ability to cope. Then in 29 December 2020, I think there was another ban then. And then in 27 June 2021, there was another temporary suspension, a full suspension, that SAB applied for an urgent interdict. And this is interesting because unlike some of the other litigation in relation to the disaster management regulations, there wasn't a full frontal constitutional challenge in the SAB matter on Section 27(2) of the Disaster Management Act. So there were quite a few sort of technical points that were taken, in terms of which what was put forward is that Regulation 29 of the lockdown regulations be declared unlawful and invalid and be reviewed and set aside, in that it was ultra vires the Disaster Management Act. And that it was procedurally unfair, and there were a few other points, but I'll go through those now. So the first argument was that Regulation 29 was ultra vires as it operated indefinitely, whereas the Cabinet and the National Coronavirus Command Council had publicly stated, and the president had publicly stated, that total ban would only be in place for 2 weeks. But the regulation itself didn't mention that 2-week period. Whereas for a number of other regulations, it specifically gave that date 2 weeks, 2 weeks hence, on which that prohibition would end. And those examples of those, I think, were gatherings at places of worship and any, and social gatherings, etc. The other argument is that the powers of the minister under the disaster management linked to suspension or limitation on the sale of alcohol and not outright prohibition. And they also found that it was implemented in a procedurally unfair manner, because it was common cause between SAB and the Minister of COGTA that no attempt had been made to comply with Section 4 of PAJA, which meant that there was no opportunity in relation to these particular regulations for industry stakeholders to make submissions. So the court was basically quite unpersuaded by these arguments for the following reasons. The court found that it was a single judge in the Western Cape High Court, and that becomes relevant later because they found that they had to be bound by the decision of the full bench of the Western Cape in the Batsa matter that related to, obviously, the tobacco ban. But the court found that the Regulation 25 is not ultra vires because the minister has the power to augment existing legislation to suspend the distribution of liquor in a national state of disaster. And also that the minister, based on the Batsa judgment that bound this court, has the power to make regulations which are inconsistent with existing laws. Now, interestingly, that Batsa judgment, and therefore the SAB judgment as well, is at odds slightly with the Democratic Alliance judgment versus the Minister of COGTA that was I believe in Gauteng, in terms of which they found that the regulations still have to be consistent and not conflict with existing laws. Just to delve a little bit deeper into that point, though, I think you would say that, like, let's say the National Liquor Act and all the provincial liquor legislation, that's permissive in the sense that if you're licensed, you can sell. But what the court did speak to is the fact that that legislation is intended for sales and distribution in a normal environment. So if you're now bringing in different rules that are for a national state of disaster, that is simply augmenting the existing national and provincial liquor framework or legislative framework, because a national state of disaster is not something that is in any way contemplated in the National Liquor Act or the provincial legislation. So this is augmenting rather than actually contradicting that liquor legislation. You might also recall, I mean, I remember this at the time just from like reading my legal brief, that one of the other main arguments was about the powers of, you know, we've got the various spheres of government, and those spheres of government can have either sort of cooperative kind of powers or exclusive powers. And the argument ran that although it wouldn't impact SAB because distributors and manufacturers are licensed at the national level, they were saying that in terms of the retailers, that falls into the exclusive province of the provinces. Sorry, I should have found a better word for that. That falls within the powers of the provinces only. So at national level, that you shouldn't be able to impact on the rights of retail, liquor retailers. But they were saying the only change that you can have to that prohibition, which is actually in the Constitution, is that if Parliament makes a change to that regime. And they were saying, but it's the Minister of COGTA has published these regulations, and therefore that is impermissible, in terms of the Constitution. So what the court found in that regard, which I found quite interesting, is they're saying by virtue of Parliament enacting the Disaster Management Act, and in terms of that act delegating certain powers to various ministers, that is Parliament doing, properly evading that, not evading is not the wrong word, or complying with the requirements of the Constitution in relation to when an exclusive provincial competence can be interfered with. So they're saying Parliament actually did interfere. It just happens to be the minister that took action, but that was under a legislative framework that was actually implemented by Parliament. To this concept of the procedural fairness or not, and this is all then linked into the Promotion of Administrative Justice Act, we just have to go back to the actual facts here, because in many different cases, you'll see that the strict procedure of Section 4 of PAJA can be deviated from. You don't always have to have public consultation. You don't always have to have a road show, because the specific circumstances of a particular case may require that a different process is actually reasonable and meets the requirements of PAJA. And I'll give you an example of that in a moment. But to give you the facts from the SAB matter, so as of 15 June 2021, information was received by government that the rate of infections and hospitalizations were increasing. Also on 15 June 2021, government apprised stakeholders in the alcohol industry regarding the possibility of a third wave. And at that time, the minister did also state that the pandemic did not allow for lengthy consultation processes. The idea that it was incredibly dynamic and it was something that no one had ever experienced. So government had to be nimble in its decision making in terms of the lockdown regulations. So the government, on advice of the Ministerial Advisory Council, imposed limited restrictions on the alcohol industry on 16 June 2021. So that was after having that stakeholder engagement the day before. But the next day they put in not a blanket ban, but it was restrictions, I think, on days of trading and hours of trading and the like. And then after 15 June 2021, it was clear to government that the infection rate continued to increase, and there was a sharp rise in third wave infections, and further urgent steps were needed. So the minister indicated that there was no purpose to repeat stakeholder engagement because it engaged with stakeholders less than 2 weeks previously. So on 27 June 2021, a group of industry players, and that was SAB, Distel, Diageo, the National Liquor Traders Association, and others, wrote a letter to the National Coronavirus Command Council saying what they believe should be done now that it was clear that things were getting more serious. So they would have, suggested, more restrictions on hours, more restrictions on days of the week, and basically, to avoid, a blanket ban. So at least, in terms of the minister's version, that letter from industry was duly given consideration, but factually there was no prior consultation in terms of the regulations that were published on 27 June 2021, which brought in a blanket ban. So SAB argued that because, yes, there had been previous consultation, but in relation to these particular regulations on 27 June, there was no consultation. And that was, that was basically common cause between the parties. So in terms of our case law, the context is really crucial in relation to whether the time allowed for representations is sufficient to meet the procedural fairness requirements of PAJA. So there was one case where a period of 48 hours was considered sufficient for purposes of PAJA because there was serious and continuing harm. I think it was something to do on a building site or what have you. And so, you're not always going to have, a full consultation period. So that application was dismissed with costs. There obviously is there's been other challenges, for instance, by Vinpro, wanting the decisions around bans or suspensions or limitations to be taken at a provincial level rather than at a national level. But I think that is still playing itself out. And so the question is what are stakeholders or individuals' rights? And it's always going to depend on the facts at a particular point in time. I mean, I remember a client asking at one stage, like, how can we still possibly be in this national state of disaster? It can't continue on forever. And that's obviously correct. So initially, if in terms of the Disaster Management Act, the initial declaration can be 3 months, and thereafter it can only be month by month. So you'll see those notices gazetted every single month, since the lockdown originally happened. And that implies that there has to be a reassessment of the necessity for the particular measures in question, either the extension of the national state of disaster or the particular, regulations under that act. And so if it goes on forever, and we're down to very low infections and very low hospitalizations, et cetera, someone could go to court and challenge the validity of the continuation of the national state of disaster. I think one challenge that does present itself from government's perspective, and maybe not so much now because it's expected that there could be a fourth wave, but if we don't have a fourth wave or we get over the fourth wave, and we continue over time to improve the penetration of vaccination, there'll come a point in time when, okay, maybe we don't need this anymore, but then that has a lot of knock-on effects, right? Because you might say to yourself as government, but I want people to continue with mask wearing, or I want social distancing to continue, or I want to still place obligations on retailers and supermarkets to have sanitizer available, and I want, but all of that would fall away if the national state of disaster came to an end. So I know at one stage, again, reading my faithful legal brief, at one stage the Department of Health was looking at bringing in its own separate regulations, and I believe that was with the view to having some of the health and hygiene requirements still continue on, even if the national state of disaster came to an end. Again, I haven't seen where those have ended up, and nothing was formally published for comment. But it is quite tricky about how to deal with the tail of COVID, if in fact we are in the tail of COVID, in the circumstances. And if this is something that's going to be on an annual basis, that we're going to need to get booster shots or whatever it might be, like the flu vaccine, then if that's completely the new normal, I mean, then you have to look at ending the national state of disaster. I don't think that can be carried on indefinitely where the facts and circumstances on the ground change. Thank you.
Alta, thank you very much. I'm not sure if there are questions in this section of the presentation, but I saw a note from my colleague, Matlo, giving her details for those non-member organizations that would like to engage on the front of PEG labeling, because this is something that we're driving very hard from the Consumer Goods Council perspective. The details are on the chat if you want to take them, so that you can contact Matlo to take discussions further. Any questions that I may have missed, colleagues? I don't see anything here, but let's go to the liquor one. Um, Somebody says that it says unknown user. The creation of policy, and this is the liquor amendment bill, which is not supported by science and research. Does so what they're saying is that, and this is maybe let's start by saying, where do you think we are with the liquor amendment bill? As you know, you mentioned, we all know that it was drafted a number of years ago. All of a sudden there's discussions about it. So from your intel, from a legal perspective, where are we with that process? And what this the guest is asking is, creation of policy must be supported by science and research. That the state has dominance on some of these, which seems to be, they are the ones that determine policy without actually taking into account science and research. And I think what the guest is alluding to is the fact that what we're starting to see is that the national disaster management regulations are being used as an opportunity, for lack of a better word, for government to introduce policy and regulatory issues that were previously not considered in the draft liquor amendment bill. And what the industry has been saying is that if there is going to be such that there needs to be proper regulatory processes that are constitutionally recognized in the country, that interested stakeholders must be given an opportunity to comment. So that's we want to find out, please, where is that regulation? And I see Tabang is asked. The liquor amendment bill seeks to redefine a minor as a person who's under 21, but in terms of the constitution and the an adult has to be 18 years or older. Is there no conflict between the two? And if there is a conflict, which one will take precedence? I think that's what Edwin is asking there.
Okay, so to take the first question first, I mean, I think if any of us had any question marks about where government sits on alcohol and alcohol abuse and the impacts of consumption of alcohol, I mean, the lockdown has disabused us of any thinking that there's a benevolence towards the wine industry or a lot of the other, the huge industry that exists in South Africa has many thousands and thousands of jobs, not only as employees, but down up and down the supply chain. And in doing that weighing up exercise, they've certainly emphasized the evils of alcohol over industry, at least at certain points in time. So that would flag to me that further regulation of alcohol is not far away. And whether that will take the form of what's in the liquor amendment bill, or whether there will be a further bill to replace that's even more restrictive. I think that has been signaled by government just in terms of how they've dealt with liquor over the lockdown period. Now, obviously, industry can be having discussions with government, and like I said before, it's everyone's right to be able to make submissions when any new regulations or amendments a bill is published for comment. But as I said, it's at least historically often where the policy viewpoint is very strong within government. A lot of those industry concerns are not fully or not taken into account. So that's I mean, I think they ultimately found, I mean, you can see that smoking was another element. I mean, they didn't repeat that prohibition again, but the sort of sin elements, government seems to be very strong in its policy against those types of products, at least as we currently sit here today. And I'm sorry, could you just refresh my memory as to the second question? I should have written it.
The age of 18 versus 21.
Yeah,
so
look,
the liquor amendment bill talks about age 21, whereas the Constitution says an adult is somebody who's over 18.
Sure. So I think you could probably, and I haven't really thought about that particular issue in any detail, and I think you could probably make arguments around that and to what does it mean to be an adult. But I don't think it necessarily follows that you can't have different ages for different things. If, for instance, there are rational reasons for that differentiation. I mean, I'm originally from the US, even though I've been here more than 20 years. And there, you can drive at 16 in my state. You can join the army at 18, but you can only drink when you're 21. So, I'm not saying our constitutional environment is the same as the US, but I'm saying it's not something that is unheard of to actually deal with someone, give people different rights and obligations at different points in time. But I do take the point that, I mean, if it flows from being an adult, that you should be able to make your own decisions, about, amongst other things, drinking, then there may very well be some arguments there.
Oh, thank you very much. I think the point that needs to be made, if I was asked my opinion by the industry, is that I think the country can ill afford to have any economic lockdowns. I'm looking at the figures here that GDP contracted by 6.9% in 2020 versus a global economic growth of 3.5. So we've lost at least 1.6 million jobs in the first quarter of 2020. That South Africa is really, really battling, particularly the SMMEs. When you look at the liquor sector, when what happens is when you close the legal channels, you're creating opportunities for illicit trade, which is now costing the company more than 6.4 billion in lost tax revenues. So I think conversations need to continue between government and the sectors, that we need to balance lives and livelihoods, that no sector should be left economically inactive, because like I said, it's mainly the SMMEs, and particularly that are black owned, that are suffering in this value chain. If you look at the wine industry, the restaurant industry, the retail liquor sector, where you have a lot of franchisees, a lot of them are black females actually that are employed in the sector, and a lot of them happen to be breadwinners. And what we're saying is that it's really critical that government starts looking at this issue of lives and livelihoods. And to be frank, and I know it's a dialogue because government is not here to defend itself, that most of the research that has been produced has not really been tested. It's research that has been provided by lobby groups who lobby against alcohol. And when the alcohol sector actually itself puts credible research that government has to look at, one of the reasons that the sector was opened a few months ago is that we provided credible research that showed that there really is no link between hospital beds and alcohol, right? Look at it now. The sector has been open to close to 2 months. We even had the local government elections, and COVID has not gone away, but the hospital beds are not full. So we really have to be realistic about what are the real objectives here of what we're trying to get to. And as a country, let's look at the vaccination strategy, and try to get as many people as possible as vaccinated. And while I have our members, and as we're drawing to a close, and others on the call, the government is calling on all sectors to really coordinate, and let's see how we can drive vaccinations. When we looked at the figures, as at end of October, only 34% of the South African total adult population was vaccinated. So and it's a far cry from the 70% that government wanted to achieve by the end of December. So as a country, we're really, really lagging behind. And when that happens, we're really threatening economic recovery, we're threatening jobs, we're threatening lives. And we need to, as different sectors and as business, to see what we can do to really accelerate and help government with its vaccine, because it's not just government, help ourselves with this vaccination drive.
Yeah.
With that in mind,
Don't even get me started. I'm very pro vaccination, and we have to do everything we can. All of us that are in our organizations are in any way an opinion leader or have roles of responsibility. We need to lead by example, and help people to have access to credible information that can discredit some of the crazy stuff that's on social media. And I mean, it makes me almost want to cry when I hear people. You know what? There's some hesitancy in South Africa, and that can be addressed through education and role modeling and all of those good things, allowing people time off to get vaccinated. But the anti-vaccine sentiment is very difficult to address, and it makes me a bit angry. Sorry, that's my own bugbear.
Well, on that note, Alta, thank you very much for your presentation. We really appreciate what you've presented to us. And I'd like to, at this stage, call on Jocelyn Katz to help us with the closing of the seminar. From our side, the Consumer Goods Council, we'd like to thank all of you who have participated, our members and clients of ENS Africa, and we look forward to seeing you again next year, hopefully in person, or we can have a hybrid model where we have an in-person thing and online, because we saw the numbers today that it was really phenomenal. We thank you for having attended. Jocelyn, over to you to do the closing.
Thanks very much, Nao, and apologies. I've had a change of tech, a change of venue. I've had a little bit of a difficult day from a tech point of view. But for me, just to say, firstly, a huge thank you to everybody who has taken the time out to attend today. I've certainly learned a lot. I've found an enormous amount of this interesting. It's not in my field, as you all will have seen. I focus very much on competition, so it's been enlightening for me. I hope you've all learned a lot today. I also just want to say thank you to my colleagues for giving of their time to share their expertise with you. And then, of course, to the CGCSA and Nao and your team. Our association has been a very, very long and happy one, and we look forward to many, many years of walking this road together. And as I say, I too hope that we can do this probably on a hybrid basis next year is probably the best way to go. I think that this ability to sort of dip in and out for topics that are particularly interesting has been great. Although I must confess I didn't tear myself away. I thought I would, but I listened to all of it, and I hope that everybody got some value out of it, and we look forward to seeing you again next year. Also, sorry, if you do have any particular questions and they weren't able to be answered during the course of the day, feel free to reach out. You know where to find us. We're always happy to help. So once again, thank you to CGCSA, to all the members, to all our clients who've joined us today. Thank you very much for being part of the day.
Thank you, Jocelyn. And I want to thank our CEO for actually, Gwarega Mangwesa, for attending the whole day. I know you had other things, but you've been sitting and listening attentively. And to my EXCO colleagues and my own team as well, thank you very much. It was a great success. Our members, we always, are grateful for the support that you give us. Thanks.
Thanks, everyone.
Thank you. Goodbye, everyone.
Bye-bye.